Thank you for joining us. Please welcome Professor Annie Lai, Co-Associate Dean for Experiential Education and Co-Director of the Immigrant Rights Clinic, who is this evening's moderating panelist.
Thank you so much, Marianne. I'm Annie Lai. I teach here at UCI Law. And as Marianne said, I teach in the clinical program primarily. I also teach courses on immigration law and the intersection between the immigration and the criminal legal systems. I have the honor today of serving as moderator of our panel. And we are going to have an exciting discussion, hopefully, about immigration law and policy. I think this is a very timely topic. As you know, many of you know, if you're participating in this webinar, you know that immigration was a focal point of the 4 years of the Trump administration. Even candidate Trump made immigration a centerpiece of his campaign. And then when he went into office, the Trump administration, individuals who Trump appointed in key leadership positions, as well as Trump himself, focused on really trying to enact an agenda around immigration that was fairly, largely restrictive. Many people would say reflected unprecedented attacks on our immigration system, in particular our asylum system. It seemed during that time that we couldn't go a week or two without a new directive, rule change, or policy coming down that we had to analyze, or for those of us who are advocates to try to defend against, with devastating impacts to the immigrant community here in the US and beyond. So some of the very, very notable policy enactments during the Trump administration, like the Muslim ban, the attempted rescission of the DACA program, attempts to limit asylum and other humanitarian protections, we will be talking about today. Now that we are beyond the Trump administration and into a new administration, we'll receive updated information about where things are at today. We'll also talk about some of the less visible or less visible trends during the Trump administration and what has happened. We have 3 experts here to join me in really giving a window into the immigration system, including some of the less visible aspects of it. With the election of President Biden and Vice President Kamala Harris, many viewed it as a new era for immigrants. We're now almost 4 months into the new administration, and there have been some changes, but there also have been some continuities from the past administration. So we'll be talking about that. For context, may go back beyond the Trump administration to where things were at during the Obama administration. So we can look at the past, not only the past 4 years, but the past 8 to 10 years. So I am going to now introduce my colleagues who will be joining me today in this webinar. First, we have Jennifer Lee Ko. She is a visiting professor of law at UCI. She'll be very soon starting as associate professor of law at Pepperdine, where she'll be teaching courses on immigration and criminal law and co-directing the Newbar Institute on Law, Religion, and Ethics. Jennifer's scholarship focuses on different aspects of immigration enforcement, including legal frameworks governing deportation and the convergence with the criminal legal system. Her forthcoming article, a draft article on downsizing the deportation state, is included with the CLE materials for today. We also have Sameer Ashar, who is clinical professor of law here at UCI and associate dean for equity initiatives. He recently returned to UCI from UCLA, where he served as vice dean of experiential education. Professor Ashar is an expert on immigration, workplace rights, and law and social movements. He recently published an article on movement law with Amna Akbar and Jocelyn Simonson in the Stanford Law Review, and I encourage everyone to check it out. Last but not least, we have Stephen Lee, professor of law and the associate dean for faculty research and development here at UCI. He is an expert on immigration law as well as administrative law. He writes about immigration law and policy across a number of different contexts, including the workplace, the food industry, banking systems, and beyond. He's working on a couple projects on deferred action with Sameer Ashar. Professor Lee's article on family separation as slow death in the Columbia Law Review is included with the CLE materials. Okay, so we've got about an hour to have hopefully a robust panel discussion. I'm going to be posing some questions to our panelists, and I'll also weigh in myself from time to time. And I encourage those of you who are in the audience to go ahead and put any questions that you have or comments in the Q&A box. You can do so now. You don't have to wait until 6 p.m. But at 6 p.m., around 6 p.m., we're going to switch to Q&A from the audience. So I'll be looking at the questions that you all submit throughout the hour, and we'll give the panelists a chance to weigh in on those questions. Okay, so I'll turn to my first question for the panelists now, which is that, as I said in my opening remarks, we're now in a new administration. And in some ways, this really presents some opportunities for those who follow immigration policy and for immigrant advocates to roll back policies from the Trump administration. Not only do we have a new administration and new party in the executive branch, but the Democrats also maintain a majority in the House and control of the Senate. So, there is a fair amount of opportunity for some policy changes. But there are also challenges to making changes at the national level. We'll talk a little bit about what those challenges are from a bureaucratic perspective, as well as from a political perspective. So my question to the panelists for each of you to engage with is really what your observations are so far with this kind of transition and this change in administrations. Where have you seen kind of opportunities, maybe developments, opportunities that were taken up, and where have you seen challenges? So we'll start with Professor Ko.
Thank you, Annie, and thank you to the organizers of this event. It's really an honor to be here, and especially to be in such company. And I would say there are really 4 immigration experts here, yourself included. So, in thinking about the transition from Trump to Biden in the context of immigration, I would say that overall, for someone who believes that the immigration system should reflect fairness, humanity, and justice, which is really a starting point that from which I'm approaching this question, that the transition is overall a good thing. And I think many advocates are thinking or were thinking about this with a measure of cautious optimism overall. And there are 2 reasons that I'd emphasize why this transition really matters. And so one reason has to do with just the general role of the president in immigration law. The other has to do with the particular relationship that former President Trump had to immigration and immigrants. So first, just with respect to the role of the president in immigration law, the executive branch and the presidency, of course, occupies a tremendous amount of power in any context. But in the immigration realm in particular, and when it comes to questions of deportation and the management of borders, the role of the president is really pronounced. And so here, immigration scholars Adam Cox and Christina Rodriguez have really powerfully made this point in their recent book, which is that because of the past relationship and the way in which Congress has set down the rules of immigration, because as a historical matter for centuries, the courts have tended to have less influence and less power to shape immigration rules. Congress has really sort of set up a system, and a system has evolved in which the president, whoever is president, has particular influence. and the policies and the priorities that the president sets tend to be, and I'm painting with a very broad brush here, but tend to go unrestricted in lots of ways. That's not to say that the courts don't matter. And we saw over the Trump administration, the courts stepping in a number of times, but still, just in general, broadly speaking, the president has a great deal of influence over what immigration policy looks like, arguably even more so than in many other areas of law. Okay, that's just as a general matter. But secondly, has to do with former President Trump's particular relationship to immigration and to immigrants. And while prior administrations certainly did things to expand deportation and detention capacity, all of the enforcement-related practices in the Trump era were in many ways more indiscriminate due to a lack of a sense of priorities. At times were more spectacular in cruelty, other times hidden far from public view. But overall, the former administration's commitment to criminalizing immigrants, to ending asylum protections, to eliminating avenues for lawful migration, and really using the immigration system to entrench racial hierarchy were just sustained and unrelenting overall. And there are lots of different examples that we could talk about and that have been written about, and sort of to the point where if we even tried to list every single one, the folks who have done that have counted anywhere from like 400 to 1,000 changes that took place under the Trump administration. And so there's good reason, again, to feel that there's good news and some measure of cautious optimism with the Biden administration. The Biden administration has shown some commitment to exercising its presidential power, to tempering the excesses of the Trump administration and restoring some measure of balance and fairness into the system. And again, the list is relatively long and it is growing. It includes things like in the early days of office, rescinding the travel bans, ending efforts to eliminate deferred action for childhood arrivals, seeking to inject a sense of proportionality and a sense of priority in terms of who should be deported, ending the migrant protection protocols program at the border, which required people to remain in Mexico while having their immigration claims heard by the courts, even just really mundane practices that were incredibly frustrating to immigration practitioners in the field, like rejecting applications because every single form might not have been filled out, even if the answer to the form really, didn't require an answer. We see changes in litigation, in the administration's stances with respect to, for example, the public charge rule or the withholding of federal funds to sanctuary cities, and that's affected cases up before the Supreme Court. And early on, the Biden administration did announce its support for immigration legislation that would create mechanisms for the legalization of potentially millions of people who lack status. All that being said, as you alluded to in your remarks, there are limitations, and many of those limitations are political. Some of those limitations are structural as well. It does seem that the Biden administration has limits on its willingness politically to prioritize immigration and even to scale back all of the changes that were instituted under Trump. The administration, for example, has continued to employ the summary expulsion of people seeking asylum at the US-Mexico border under a program known as Title 42. It's a practice that the Trump administration had justified on public health grounds related to COVID-19, but that in many ways has really come to signify a lot of the hostility over the border. The Biden administration has also experienced some early setbacks in the courts where states that are hostile to this federal government's agenda have brought lawsuits. And so, for example, one effort to institute a 100-day moratorium on deportations was enjoined in a federal court. With respect to the management of the southern border in particular, many people may have seen yesterday's comments from Vice President Harris, where she stated in Guatemala, do not come, told people in Guatemala, do not come to the United States. So again, we really see some limitations on the administration's willingness to fulfill some of the legal obligations and protections that already exist under both international law and domestic law with respect to asylum. And with respect to the president's early announcement of support for comprehensive immigration reform, despite some changes in the composition of Congress, there hasn't really been all that much progress with respect to legislative reform as far as legalization options are concerned. So again, cautious optimism. I think we still have to see how a lot of things will play out in the months and years to come.
Thank you so much, Jennifer. I think that was really, really helpful overview of where we are. So I will turn it now to Stephen. Do you want to share some of your observations from the first 4 months?
Great. Thank you for that introduction. Thank you, Jennifer, for setting the table, and thanks to the organizers for this opportunity to talk about this change in administration. So let me just start with a basic observation about why implementing policy is very difficult at the start of a presidential administration, any presidential administration. When I talk to my administrative law students, I encourage them to recalibrate or rethink what they think a win looks like in this realm. So we go to like a lawsuit setting, a court setting, and a win usually means some sort of settlement. Sometimes it leads to judgment, but that's not really how victories in the administrative settings play out. It's often about trying to set up programs that are then hard to undo for future administrations. So as a result, if you look at things from the perspective of the outgoing Trump administration, a win looks like a program that is not impossible to reverse, but one that requires future administrators and future presidential appointees to incur a significant number of costs to undo. So I think that's important, because when you have an administration that ran on a platform of trying to unfurl and roll out all of these programs related to more inclusionary policies, it's going to take some time for the Biden administration to do those things, because they're busy trying to undo all of the programs that have been set in place by the Trump administration era appointees. Okay, so with that basic framework in mind, I want to point to 3 specific areas where I think the Biden administration is, struggling, and I think all of us as interested, community members should keep an eye out to see how things develop over the course of the next couple of years. Okay, so first, I think the most obvious example of trying to undo a prior administration's harms is the family separation policies that took place at the border. Many of us were horrified when children were taken from their parents at the border. And so this is one area where I think the Biden administration is feeling great political pressure to actually repair the harm that was exacted upon non-citizens coming to this country. So you have a family reunification task force. They're trying to slowly, build out the database that wasn't put together in the first place to even identify all the people who have been separated. I took a peek at the report that came out just in the last day or so, and about 1,700 children have been reunited, but I think there are still over 2,000 that are still awaiting reunification, and there's still another 1,700 whose cases have to be processed and figure out where they belong. So again, the program took place a couple of years ago, but we're only now making our way through the pool of cases to try and reunite them. And I think the Biden administration plans to try and use humanitarian parole as a way to bring in people who have been deported into the United States to be reunited with their children. I think there's going to be a long-term challenge. Even if you can get everyone here and identify everyone, there's going to be a long-term challenge of figuring out what then. So once people have been reunited on these short-term humanitarian bases, is there going to be some way for people to get a more permanent basis for status? So is it going to be asylum? Is it going to be a family-based petition? Is it going to be a law enforcement visa? I think those are all things that we should be thinking about. A second area that is closely related to this has to do with preventing future separation. And that, of course, is closely tied with asylum policy and the US-Mexico border. So Professor Ko talked a little bit already about how the Biden administration is struggling right now with how to manage the continued flow of people seeking asylum, the continued reliance on Title 42. Again, people are criticizing the administration as effectively relying on a cop-out. I mean, the pandemic is not what it used to be, and it seems like a kind of poor and blunt management tool. So I think this is one area where, again, we will hope that the administration will change course. The Biden administration was able to avoid certain difficult questions that were before the Supreme Court. So, for example, there was a lawsuit, Mayorkas versus Innovation Law Lab, which had to do with whether or not these migrant protection protocols were, again, migrants were forced to wait while their claims were being adjudicated. That was before the Supreme Court, but that's been, mooted because now you have the end of that program. So there's, we're not going to get the Biden administration not going to be forced to answer for that. Similarly, Trump versus Sierra Club had to do with whether the executive could divert funds earmarked for one purpose and put it towards funding of the border wall. Again, that case has been mooted because Biden has prohibited the use of taxpayer dollars to build the wall. So again, I think there's some areas where the administration was able to pretty swiftly undo some of these things. But again, I think the asylum is going to be where all of the action is going to take place vis-a-vis preventing future family separation. Okay, the third and final area where I think all of us should be paying attention are, I guess, broadly, what I would call temporary relief programs. Again, I think the most obvious example is the Deferred Action for Childhood Arrivals, the DACA program that was created under Obama, and then which the Trump administration tried to rescind. The Supreme Court held that the Trump administration did not take proper steps in trying to implement its rescission policy. Again, another great example of how it wasn't that the administration could not undo DACA, is that they have to incur greater costs in order to do so. It remains to be seen whether or not Congress is going to actually pass the American Dream and Promise Act of 2021, which would create a pathway to citizenship for many of these recipients, or whether the Biden administration is going to continue to rely on deferred action as a tool. A related question, or a related program, has to do with TPS, or temporary protection status. This is a kind of humanitarian form of relief that allows otherwise removable non-citizens to apply for a temporary reprieve. This is tethered to the emergence of a disaster or some sort of humanitarian emergency in their home country. And so effectively, the executive has to designate an emergency in a country and therefore allow people who are in the United States to stay at least temporarily, usually in the range of 18 months. Ordinarily, what happens is that every 18 months, then the president has to redesignate the country, and so as a result, there's a kind of cloud of uncertainty that hangs over a lot of these non-citizens. Recently, the Trump administration redesignated Haiti as a country that was going to get PPS benefits. They added Venezuela and Burma. So again, as is the case with DACA, hanging over all of this is the question of whether and to what extent Congress is going to do anything to provide a more permanent lawful status. In the absence of that, I think we can all expect to see a reliance on these temporary programs to manage the lives of migrants. Again, and I want to emphasize that these are really just, very, very rough approximations of relief that path to a green card would provide. Again, some of the work that Sameer and I have done, some of the work that empiricists have done in this area have really documented well the psychic strain, the emotional trauma of having to go through this process of continued uncertainty. And so again, I think this is an area where all of us should be paying attention in the coming years. So with that, I'll stop.
Thank you so much, Stephen. So I'll turn it over to Professor Ashar.
Thanks. Thanks, Professor Lai, for moderating, and appreciate both Professor Ko and Stephen for setting the table for me. In some ways, it allows me to make a more meta comment than a directly policy-specific comment. Although I will say, and some of this has been mentioned, the end of the travel bans, number one. Number two, the end of the revocation of public charge rules, which was wreaking havoc particularly in low-income immigrant communities. And third, the expansion of temporary protective status that Stephen just mentioned were all, I think, probably, to me, the most significant changes, and probably have made had a deep impact on people's lives in the near term as a consequence of the change in administration. So on those points, I would say I definitely feel Professor Ko's guarded optimism about the changes and the consequences for individuals, families, and communities. I also want to note the late, great deportation moratorium, which was also mentioned, I think, by Professor Ko. That was significant in a couple of different ways. One is it was highly meaningful as a symbolic act. That is, in a lot of ways, it was actually a policy articulation of a movement demand from the Obama-Biden administration that is not one more made by immigrant activists. And so to have that be a possibility at the outset of this administration, I think, was highly significant, and also suggested that there could be moments in which any presidential administration could basically declare a deportation moratorium and the sky wouldn't fall, right? Just like taking that idea into our heads can kind of alter the horizons of what we think are possible. Then, district court judge obviously stopped that policy from going into effect. But it links back to, I think, what I'll come back to in our second round of questions with regard to movement ideation and how that can really alter what's possible. But first, I want to get a little pessimistic as a compliment to Professor Ko's commentary. I just read a book by Ming-Shu Chen, who's a professor at University of Colorado, called Pursuing Citizenship in the Enforcement Era. And my reaction to that was to say, enforcement era suggests a time period that's limited in time. There's a start point and there's an end point. And what it seems to me that we're living through in our lifetimes is basically, we live in an enforcement episteme, or we are all basically owned or have to deploy enforcement epistemology, right? The way in which we know about how things work in the regulation of migration in the United States is governed by a set of unchangeable facts on the ground. Those are national borders, the existence of militarized forces that basically guard those borders and that also engage in interior enforcement. The existence of nation states, just in and of itself, really creates a kind of enforcement epistemology that we all live within. And what I would suggest, turning Hiroshi Motomura's idea of phantom norms, right? Hiroshi Motomura talks about the fact that because constitutional law doesn't directly apply to immigration law, judges have to find phantom constitutional norms in the immigration statutes. I would suggest turning it on its head and thinking about it much, much more pessimistically, but I think more realistically. What I think we have are phantom norms of exclusion and immiseration and labor extraction that are sort of a part of the US history of migration regulation, and that are part and underlying the statutes, but that operate in silence, that don't operate at the surface. I would suggest that those are phantom norms that are born of a deep-rootedness of settler colonialism, Orientalism, racial hierarchy in our thinking, and also the need for us to believe that we're innately good and that we are involved in a linear progress narrative. That is, America is getting better and better. The moral arc of the universe bends towards justice, and we are on that arc, and Biden is our guy to get us there. But what I would suggest is that living on that arc and maintaining these illusions prevents us from seeing the horizons beyond the enclosures that we are placed in as a consequence of buying into an enforcement epistemology. And I would suggest those are more abolitionist horizons. And so as a consequence, every commentary that we make, like today, every policy fix that the administration issues, all comes from within an enforcement epistemology that contributes to the enclosures that we ultimately find ourselves in. And you see this with Vice President Harris's comments, I think it was in Guatemala, where she advised people not to come, as one of the questioners, Felicity Figueroa, suggests, is in violation of international law and US asylum and refugee law. But what that is a comment that is very much rooted in a kind of enforcement epistemology, an understanding of the role of the United States, the fact that we are trying to keep people out, and that we're trying to maintain borders as they exist now. I would suggest another policy initiative that's just been issued by the Biden administration. It's the renewal of prosecutorial discretion that was part of the policy tools that the Obama-Biden administration used, and that Stephen and I have actually written a little bit about, and many others have written about as well. But you know, in the interviews that Stephen did with actors in the administration, what was found was that discretion actually passed down to frontline agents, like Border Patrol agents and ICE agents in the field, who ultimately controlled policy and practice. So though Cox and Rodriguez might say it's the president that controls immigration policy in large part, what our findings indicate is that it's actually the rogue agents who are actually in control of policy and practice in the immigration legal system, and giving those officers and frontline lawyers who work closely with those officers to prosecute immigration cases the authority to exercise discretion does not ultimately alter the system. It merely reinforces the system as it is. It maintains the deportation system and continues to create misery. So maybe just one more really highly optimistic and positive note. That is what is operating? Why do we live within an enforcement epistemology? And that is, it seems to me, is this sort of what has been described by philosophers as a kind of and political theorists as liberal nationalism. That is, we need to have hard exterior and a soft interior. That we maintain the hard exterior so that we can build up a polity on the interior. This is the work of Michael Walzer. And everyone in the interior then enjoys rights and is given rights and an ability to participate in a democratic society. But without that hard exterior, we would be flooded with people and we'd be unable to really endow people with rights and the ability to participate fully. The problem with that analysis, which I think undergirds all of immigration law and all of immigration policy and practice, it's an acceptance of an underlying structure that the purpose of immigration law, policy, and practice is to screen immigrants at entry and then after arrival, both ex ante and ex post, in the words of Adam Cox and Eric Posner. But it flies in the face of things like the persistence of a myth of due process, when people like Professor Coe have amply documented the fact that process doesn't exist for those who face enforcement authorities. It also, liberal nationalism creates incentives for the immigration bar to preserve the myth of due process, to show that lawyering might matter, when for so many families and individuals, lawyering really does not make a difference. There is no process that can help so many people because of the way in which the system is shaped. The other, lie about liberal nationalism is the idea that we have a soft interior, when commentators like Devin Carbado have suggested that we actually engage in racial naturalization. That is, we bring migrants into the United States and we incorporate them into an enduring US racial hierarchy, both as victims of racism, but also as perpetrators, depending on where they fit on that hierarchy. The last thing I'll say is that the comprehensive immigration reform proposal that was proposed by the Biden administration in the first day or first week, whatever it was, it was largely a rehash of the last unsuccessful comprehensive immigration reform proposal that was put forth under the Obama administration. There's been some great critiques of this approach to comprehensive immigration reform in the literature. One I'll call your attention to is by Munir Ahmed, who talks about earned citizenship, this sort of long provisional period when people are forced to have, I think, blue cards before they get green cards, before they get naturalized, as periods when they are on probation, and any misstep, any entanglement with the criminal legal system endangers and takes them off their path to citizenship. And what Ahmed argues is that it's an example of sort of neoliberal policymaking, effectively forcing each of us to prove to our country that we belong here, and some of us disproportionately, because of the levels of policing in our communities, forced to stay clear of police in ways that are very, very difficult. And so even the proposal that is dead on arrival in Congress, in week one of the administration, is heavily flawed. And so, what I'll try to gesture at when we come back around again is maybe some other alternative approaches to thinking about immigration policy that might get us out of the enforcement epistemology.
Thank you so much, Sameer. I'll just weigh in, briefly with some of my own observations, and then we'll move to my second question for the panelists. One of the areas in which I focus in my work and scholarship is the kind of invitation, in some cases, the conscription of local law enforcement into the apparatus of federal immigration enforcement, and that has been documented by many. But from that perspective, and I'm talking, about programs like Secure Communities, which I think many in the audience are familiar with, 287G, which is a program that deputizes local officers to participate in civil immigration enforcement, to less formal arrangements like ICE agents being in jails and having access to various databases that are maintained by law enforcement. These kinds of collaboration, these kinds of entanglement between the criminal legal system and the immigration system have been a defining feature of interior immigration enforcement over the past 4 decades. And one of the notable things that the Trump administration did was really to try to cement that into place by using threats to, as Professor Ko mentioned, threats to withdraw funding and other tactics to kind of strong arm local jurisdictions into participating in the Trump administration's enforcement agenda. From that perspective, as well as kind of looking at interior enforcement in general, I think that one observation I've had is that with this administration, others have talked about how in some ways we are hopeful, and in other ways we have started to feel some disappointment in kind of how far the new administration has been willing to go. But I think, this change in administration in 2021 allows us to think about going farther, making, more radical demands than perhaps we were making during the Obama era. And, I think it's not just about trying to reverse or undo the damage of the Trump administration, but about, how the immigrant rights movement and immigration law scholars, practitioners can make demands that reflect 2021 and reflect the lessons learned from the Obama administration and the Trump administration. I think we are helped in two regards. One is that, at the time that candidate Biden was vying for the presidency, there were other candidates in the field making radical demands or bold policy proposals. For example, the repeal of Section 1325, Title 8 USC Section 1325, which criminalizes the act of migration and was really kind of at the root of the zero tolerance and family separation policy of the Trump administration. Secondly, the renewed attention last summer and perhaps greater appreciation for racial justice in various institutions in our country. I think both of these really open up the field for us to go farther in our demands and for policymakers to consider new proposals that go farther than even the Obama administration. Of course, there are challenges, but I think I just want to put that on the table. With respect, in particular, with respect to local law enforcement participation and interior enforcement priorities, just to provide some more information, as Jennifer mentioned, the new administration has taken some steps to end policies of trying to strong-arm local jurisdictions into acting as immigration enforcers. They've stopped fighting some cases in court to kind of try to reverse somewhat the damage of the Trump administration. This administration has issued some memos to try to reestablish some semblance of enforcement priorities in interior enforcement. So, in the first week of the administration, the Pekoski memo, which Professor Ko mentioned, which included the 100-day moratorium, also included some articulation of just other individuals who would or would not fall within the enforcement priorities of the new administration. That was followed up with in February by another memo by the acting ICE director. And then just last week, there was a memo sent out to attorneys who represent the agency in deportation proceedings about giving them some direction about what cases they should fight or which cases they should consider for administrative closure or termination. So there have been these efforts to kind of establish some priorities and really to say that some people should be beyond the reach of enforcement action in theory. In reality, one thing that we have noticed if you're in this area is that the numbers of immigrants who are in ICE detention are quite low. They're really low for kind of, if you look at the past 15 years of detention statistics. But these numbers were already falling because of COVID-19. The Trump administration was a target of litigation in federal court around conditions for humane treatment of individuals during the time of the pandemic. And so those numbers were already falling. So some additional people have been released, but thousands remain in immigration detention, including many who do not fall within the enforcement priorities laid out in the memos that I just articulated. And other programs that have been historically associated with racial profiling and civil rights violations, like the 287G community program and the Secure Communities program, have not been terminated. They're under review by the administration, but under review can really lead to any result. Okay, so with that, I'm going to turn to our second question. I'll give each of our panelists a few minutes. Maybe we can keep it to 3 minutes to go deeper into a particular area or issue, perhaps that was alluded to in the first round of remarks, that you want to call the audience's attention to. So we're going to start this time with Sameer.
Great, thank you. Well, just starting where Stephen kind of ended, which is potential for executive relief, different forms of executive relief that is not a green card and a path to citizenship, but along the lines of DACA. again, DACA was very much a response to movement activism and movement demands on the administration, and the administration really had to be pulled to it with its feet dragging, its lawyers holding them back, had to be brought to that policy. But so it's far from perfect for some of the reasons that Stephen alludes to, the liminal nature of the grant, and the fact that it creates a misery all its own. However, it does keep people in the United States to fight another day, and to keep pushing for paths to citizenship more broadly. So, the Dreamer Act that Stephen mentioned, ag jobs, and as well as the legislation having to do with providing a path to citizenship for people with TPS are all important pieces. The question as to whether or not they can be incorporated into some kind of reconciliation bill is an open one. I don't know if there's hope that the Democratic majority in the Senate will take risks in that way, and whether they would abide by an order of the who knew, the all-powerful parliamentarian, as to whether or not that kind of legislation can be a part of reconciliation bills. But that's one thing to keep an eye on. In terms of sort of more core movement responses to what is happening now, I just call your attention to a few different types of campaigns. One is campaigns to degrade and abolish immigration enforcement. So that includes local disentanglement campaigns that is in response to the programs that Professor Lai talked about, 287G and Secure Communities, including the California Vision Act, which is pending right now in Sacramento. These are, there has been really exciting local activism all over the country in red and blue states, not just in California, but in South Carolina and Georgia and other places, again, from the grassroots activism forcing local sheriffs to stop cooperating with immigration authorities. This is movement activism. These are movement messages. The second part of degrading and abolishing immigration enforcement, I call your attention to the Free Our Future document that is a part of the MCLE documentation. It's by a group called Mi Gente that I know Professor Coe works closely with. And the focus is on decriminalization in the interior and demilitarization at the border. That is, again, kind of extending abolitionist horizons, disinvesting in the military immigration enforcement and criminal immigration enforcement, and reinvesting in communities instead. And one particular campaign that Mi Gente has been running that Professor Coe may talk more about is the sort of focus on tech and surveillance as being a sort of key tool of law enforcement against immigrant communities. And the third thing I'd call your attention to in this category of degrading and abolishing immigration enforcement is the Federal Power Act, which hasn't been, to my knowledge, reintroduced, but that would strengthen the capacity of workers who might be in a dispute with their employer to complain without fear of being retaliated against. There are visas extended in the proposed legislation for courageous workers who might engage in a dispute with their employers. The second category is something I would call democratic participatory, work and campaigns that advance democratic participatory logics. I think the PRO Act, which is being pushed by labor, is the sort of the key piece of legislation currently pending in the Senate that would advance not just unionism, but would set back the dictatorship of employers in the workplace and allow even non-unionized workers to engage in concerted activities. It would also fix the problem of misclassification, where so many immigrant workers, so many immigrant essential workers are misclassified as gig workers or independent contractors, and thus don't have basic employment rights and the right to organize with each other. So that is a key piece of legislation. Again, the question as to whether the Senate majority will take any risks and push legislation is an open one. But on this one, Joe Manchin is actually in favor of the PRO Act, if that means anything. So we'll see where that goes. The final category I would step forth is kind of a cross-movement abolitionist and universal approaches. So things like the Movement for Black Lives policy platform, the work of Gente, which I talked about earlier, the work of the Red Nation, what they call the Red Deal, as well as the Sunrise Movement and Green New Deal. These are adjacent to the immigrant rights struggle, but essential in creating autonomous community control and power, giving more power to those who are currently marginalized, including immigrant individuals, families, and communities. And any kind of progress in immigration will require close collaboration, coordination across issue areas, and with attention to what is happening in, say, for example, the area of climate change, which will both directly affect migration policy because of climate migration, but also indirectly in terms of building up constituencies and political power within the United States to engage in more liberatory lawmaking efforts and campaigns. So those are some categories that I would suggest we might keep our eyes on.
Excellent. I'm going to turn it over to Jennifer, and I know you have some slides to put up.
Great, thank you. This is really such an incredibly rich conversation, and I'm learning so much as we go along. In response to the question of what we're paying attention to, again, there are sort of hundreds of things to pay attention to, and I think many of us who are engaged in the field really are looking every day to see what new developments take place, what comes out of the administration, what comes out at the local and state level, what happens in the courts, right? What new policy initiatives are blooming. And I really do want to echo kind of the power of the imagination and persuasion that's coming out of the grassroots movements in terms of what has become possible and that has become so influential. But I want to take a step back and think a little bit, and in terms of this conversation about the Biden administration, ask us to think about where this administration will fit in terms of an overall historical trajectory in which this deportation state has grown and grown over not just the Trump era, but over several administrations. We might place that back to Reagan, maybe Bush Sr. I think that the Clinton era is incredibly important because former President Clinton signed into law legislation that had been passed by Congress that has in so many ways made the immigration laws just draconian and harsh in lots of different ways. And so the question I would pose is, well, what will this administration's legacy be, and what will be handed on to the next administration, including the possibility that the electorate can be unpredictable and the next president could be one that shares the kinds of sort of nationalistic and white supremacist impulses that Trump had. And so there, it's helpful to just take a step back. I can't take any credit for these slides. They appear in an essay written by Douglas Massey called The Bipartisan Origins of White Nationalism. And he really focuses on the immigration context. But this first slide shows just the growth, for example, of Border Patrol's budget over time. And you can see where the lines take us. The next one shows the increase in ICE's interior enforcement budget. And, for whatever variations occur, what we do see is overall growth over time, right? That has expanded funding such that ICE and CBP together essentially amount to the largest police force in the United States. And then finally, just is a slide on detentions. And while we mentioned that detentions right now have reached a low in large part due to COVID and people being released from detention, just overall, the number of people who are being physically incarcerated in prisons pursuant to civil immigration violations has grown over time. So those are the slides that I'm going to share. I'm just going to stop my share screen. So there are a couple of things that I think we could be paying attention to that go to this broader question of how big will our deportation force be? So one of the more obvious ones is just that funding question and how large the budget is. Again, certainly here, the grassroots movements have drawn so much attention to levels of agency funding, but funding tends to be sort of an opaque process. It tends not to be one that captures, the headlines and that many of us are paying attention to. In the latest proposal from the Biden administration, the administration more or less proposed an even level of funding, so not necessarily an increase. But I think the question becomes, will there be room for decreases and for meaningful changes in the trajectory that has already taken place? A second question has to do with, again, Professor Ashar is right. It's not just about the president. It's really also very much so about the frontline agents who are powering our deportation and detention capacity, ICE agents and Border Patrol agents who actually really have tremendous power under the laws to make decisions, even to directly issue removal orders against people. So here are things like agency culture matters, the influence of the ICE and CBP unions, the nature of supervision and staffing, how hiring takes place, and how just the sort of civil servant and frontline agent ranks of ICE and CBP will play out. That's a second area that are worth taking a look at. And then a third one, and again, all of these are ones that tend to kind of escape public attention, are the types of contractual relationships that ICE and CBP entered into. We've talked about relationships with local law enforcement, but I also want to draw attention to relationships with private industry. So there has been a fair amount of attention towards the role of private prisons in immigration detention. There is some growing attention being paid to the role of private surveillance companies and data brokers, data mining companies. Here, as Professor Ashar mentioned, the work of Mi Gente and Just Futures Law has really brought this to light, and there's a slew of reports that a number of law school clinics and others supporting this work have recently released. So sort of law enforcement efforts that fall along the lines of facial recognition technology, license plate scanning, they've all enhanced the capacity of deportation agents to conduct this work. The federal government began exploring these relationships pre-Trump, and we see the kind of ballooning of AI and technology being used in the criminal law enforcement as well, where very powerful critiques have been made. But it is worth noting also that even with the strength of the critiques that exist in the criminal law enforcement area, in immigration, the types of normal constitutional protections that we would expect to apply in criminal law more or less don't exist. So there are all kinds of reasons for which we should be concerned about this proliferation of technology and relationships, essentially public money that's going to private companies to conduct this surveillance work. Reasons to pay attention and to see what develops. So I'll leave it at that. And we'll look forward to continued conversation.
Thank you so much, Jennifer. And Stephen?
Great. I'll be quick because I want to leave time for questions. So the place where I'll be spending a consistent amount of time for the next few months will be the Family Reunification Task Force that I mentioned at the outset. The reason why I think it's important is because so much of executive action typically is governed or is defined by uncertainty. But this is an area where we actually do have a couple of hard and fast dates. So for example, the reason why we have a task force report that came out just in the last 24 hours is because of an executive order that President Biden signed in early February that said that an initial report had to be published within 120 days. And the same executive order thereafter required that the task force would be required to issue reports every 60 days to get an update. And then at the conclusion of their filling out their mandate, then they have to issue a final report. So, it's beginning of June right now, so we know that in the beginning of August, we can expect another report and another update as to the progress of the administration toward repairing the family separation harms. Now, so I think just from a basic government transparency monitoring standpoint, that's a great thing. But there's also a second reason why I think it's worth all of us paying attention, and that has to do with the kind of story that we're going to tell ourselves about family separation. What does and does not count as family separation? So one of the documents we circulated in the materials was an article I wrote called Family Separation as Slow Death. And it's really a concern with limiting our understanding of family separation to the most spectacular, to the most horrific, to the most troubling instances of families being torn apart. And that's not in any way to diminish the harm that flows from those examples. And that's not in any way to deny the tremendous work that advocates have put into trying to, again, litigate in this area and repair the harms. At the same time, I am worried that through this task force, you'll have a kind of hardening effect where the only reason the public might feel a sense of outrage is when we see the horrific. Because as I sort of am happy to talk about during the Q&A, there are a whole range of issues, a whole range of instances where families are kept apart and they sort of go unnoticed because of the realities of time, because things unfold over the course of months and years and decades. And that itself is its own kind of harm. Just to give you one statistic, I think more than half now of the undocumented population has been in the United States for more than 10 years. And because of the large constellation of punitive laws, that means it's almost certainly the case that there's some close family member who is left behind that the migrant has been unable to connect with. So again, I think all of us can expect to revisit the question of family separation every 60 days. And in doing so, I hope that we encourage, and in some cases, if we have to, force the administration to think broadly and expansively about the range of family separation issues that we care about.
Thanks so much, Stephen. So I am actually going to cede my time, my comments, so that we can have some time for Q&A. I encourage the audience to go ahead and type your questions into the Q&A box. We did get a couple of questions while the panel was going. I'll just read out the first question, which is, when will the term illegal alien be removed from the legal lexicon? I think this is an important question. I'll just note, and perhaps the question asker was alluding to this. In April, the Biden administration issued a memo to immigration agencies directing them to not use this terminology in their business, in the business of the executive branch. And so this doesn't change the use of this term in legislation that is within Congress's domain, but it is a step in the direction that I think the question asker, Kirk Davis, is suggesting. I don't know if any of the other panelists want to weigh in on this question, and then we have one more so far.
The only thing I would add is that these sorts of things happen, I think, both bottom up and top down. So I think what Professor Lai alluded to is kind of one area in which the law might be able to implement change from the top down. Another area along the lines of the top down narrative would be the Supreme Court. So several years ago in 2009, there was a case called Mohawk Industries versus Carpenter. It wasn't a immigration case; it was actually a civil procedure case. But it was one of the first opinions written by Justice Sotomayor, and she used the term undocumented immigrant. And I thought it was remarkable because it was the first time those words were used to refer to a non-citizen with that kind of lawful status or unlawful status. And I think progress is slow, and I think it's also going to mirror the kind of uncertainty that surrounds terminology. Recently there was a case that came out from the court, Nis Chavez versus Garland. This was a divided opinion, but ultimately it provided relief for the non-citizen. What was interesting was that Justice Gorsuch wrote the opinion actually finding relief for the non-citizen, and he used the term alien. And then Justice Kavanaugh, who was objecting to this, and he effectively wanted an outcome that would hurt the non-citizen, he was using the respectful term unauthorized immigrant. So, you know, like these things aren't linear. They don't track, you know, a kind of predictable outcomes. So I think it's a negotiation. So I just think that those are areas where it might be worth, you know, thinking about, again, as more people bring cases to the Supreme Court, sort of encouraging the court to embrace that terminology.
Until you said the Kavanaugh thing, I was going to say that this is an example of maybe an epistemological assumption about the immigration system. And so when we change terminology, maybe we actually are changing the way we think about things up and down the system. But then the Kavanaugh thing, you know, suggests that, and in fact, once again, it can be used, changes in terminology can be used to indicate wokeness without actually restructuring the system as it is. And you know, and Kavanaugh, I think, has been on the wrong side of most immigration decisions, or all of them so far in the time that he's been on the court. But anyway, I'm not saying that it's not an important fight, and I'm glad that the Biden administration made the changes that it did.
So let me pose the other question from the audience to see if any of our panelists want to weigh in. This comes from W.J. Kelly, and the question is regarding legal immigration or kind of comprehensive immigration reform. What do folks think should be the top 3 or 4 goals or principles to govern legal immigration pathways? I'm happy to start with a couple comments, and I think, you know, I think there's a set of questions about categories of people who should be allowed to immigrate to the United States or to legalize their status, which is another thing that you know, Congress can do in comprehensive immigration reform package. There's a different set of questions about kind of like what else gets included in that package, and what are the terms by which people are allowed to legalize their status or immigrate to the U.S., or the terms by which they can be eligible to do so and may be excluded from doing so. And so on the second category, I want to just kind of bring back up or lift up this idea that I was going to talk about, which is, you know, I think the reality is that even in the Biden-Harris administration, and we can see this reflected in some of the interior enforcement priority memos, is that we have not moved away from a problematic reliance on the criminal legal system as both a pipeline to deportation and as a way to determine the fate of non-citizens, whether they're trying to come into the United States or trying to legalize their status or gain a more secure status in the United States. And this has had a disproportionate effect on Black immigrants in particular, who have gotten less attention in the immigration system. And so some of the laws that Professor Coe alluded to before that were signed into law by the Clinton administration, those 2 laws that she referred to, essentially define the landscape of what we're working with today. In terms of contact with the criminal legal system that can land a person in proceedings, but can also exclude a person from benefiting from legalization programs or forms of immigration relief or a humanitarian relief that would allow them to stay in the United States. And not only is this the case, but a person who has a conviction that is expunged, in other words, the conviction does not exist under state law, would still face the immigration consequences under federal law. And that's a result of the 1996 laws. So until we revisit that, I think we're going to have this very troubling and difficult, challenging reliance on the criminal legal system as kind of a defining feature, defining sorting mechanism of who gets to benefit and who doesn't. And I would encourage that to be, you know, one of the principles or priorities of policymakers and advocates. So let me see if any of the other panelists want to weigh in on this question.
I mean, I might just hop in to say, I mean, under current law, generally speaking, people are able to migrate based on family relationship, based on work relationships, or because they've suffered persecution. They're not terrible principles. We've really warped them in the sense that the numbers of lawful visas that we've allocated for people in these categories is tremendously out of whack with demand. And so there's no particular, there are reasons why, but the end result of having, for example, 15 to 18-year waits for people who have family in the United States and want to migrate is unreasonable, right? The effect of incarcerating people who are fleeing persecution, having not necessarily wanted to leave home, right? But where that factor exists, is not really the right system to structure. And so I might suggest a system that moves just a little closer to honoring some principles of supply and demand. Many people like their homes. Many people love their home countries. Not everybody wants to live in the United States, but perhaps if we can design a more sensible system, we might align that system more towards, again, sort of fairness, equity, and justice in ways that resonate with at least some Americans.
Yeah, I think it's worth bolstering the point that both of Professors Coe and Lai have made, that we need to decriminalize and get criminal law out of immigration law. It's no longer, it's not, I mean, I don't want to say no longer because it suggests that it once did. It's just not doing the work that we think it's doing. It's so overly broad. It's so tied to a criminal law legal system that's racist in design and implementation, that it's just excluding a whole cross-section of individuals that I think that in the abstract, everyone would agree should be allowed to stay in the United States, either because they have ties here or because they're contributing. And again, I'm not, there's a conversation we could have about like ambitious political plans that could arrest us, just take us out from this kind of very narrow sense. But even within this kind of narrow universe, criminal legal definitions are so broadly defined in the immigration context that it's causing unnecessary human misery. Along those lines, I would love to see a flattening of the unauthorized community. What I mean by that is the unauthorized community is divided between people who are visa overstayers and people who are surreptitious border entrants. And that distinction actually has significant consequences for a range of benefits. So for example, ordinarily, if you're a visa overstayer, you can still adjust your status to that of a green card holder through marriage to a US citizen. In most cases, that option is not available to people who are surreptitious entrants. And again, because of demographic realities, that means that because the vast majority of unauthorized migrants who are Asian American or Black are visa overstayers, and the vast majority of surreptitious entrants are racialized as Latino, you have a disparate impact in the way these benefits are allocated. So again, I just feel like it's unnecessarily punitive. It perpetuates racist hierarchies. And again, I don't think it's really doing the thing that lawmakers would essentially want it to do. So I think we should just get rid of that distinction.
Sameer, do you want to weigh in on this question?
I just think it's an existential question. I completely agree with eliminating the influence of the criminal legal system and the immigration system and disentangling them for good, because it doesn't work for the reasons that both you and Professor Coe have suggested. But the question of climate migration sort of is an imminent question and pressure that will be placed on nation state borders. And the question of whether or not we're going to descend into climate barbarity or whether we're going to aspire to climate solidarity, I think really makes this a very difficult question to wrestle with in a period of renewed authoritarian, right-wing governments around the world, and the kind of reassertion of nationalism along various ethno-nationalism along various lines. But this is really, I think that's going to be the fight that's going to be just put on our doorstep that we're going to have to grapple with.
Thank you, Sameer. And we didn't get to all the questions, but I did notice it is time. We're going to have to end our session today. I want to thank all the panelists, of course, to our UCI staff who made this event possible, and as well as the audience who stayed through the entire hour and 15 minutes. Thank you for engaging with us in this conversation, and we hope to see you soon.